Thank you for coming to today's CLE. Today we have my law partner, Austin Martin, talking about mediation in the age of Zoom. He's an attorney and a mediator, so he's going to be able to give us sort of both sides of, the table on that one and what he's learned as, an attorney in I think hundreds, if not thousands of mediations, and as a newly licensed mediator. So if you guys have any questions, I know that we're webinar style, but please feel free to put them in the chat. I'm going to be watching it and we'll try to sort of answer them in real time. Otherwise, if you want to save them to the end, we're not going to have an official question answer period, but I know we're going to try to save some time to, respond to anything that we happen to miss during the course of the CLE. And at the end of the hour, I'm going to go ahead and put the course number into the chat box, as well as give it to y'all in the video so that you have it. You can get your CLE credits. So without further ado, I'm going to let Austin take it away.
Hey y'all, my name's Austin Martin. I've been an attorney. I've been practicing a little over 6 years, and a few months ago became a certified mediator. I've probably done hundreds of mediations as an attorney, and most of those have been for personal injury. I've done one family law, I've done a couple of construction, but my focus, my experience is on personal injury. So today I just want to kind of give you all a roadmap, being that this is Houston Young Lawyers. I want to talk about mediation in general. I don't know if there's anyone out there that hasn't mediated a case. Maybe they don't know what to expect in mediation. So I want to kind of go over, everything in general, kind of talk about what it used to be before COVID and, really what it's like now over Zoom. And then just kind of go through some stuff like, benefits of mediation and settlement, what happens if there's an impasse, just really general stuff so that y'all know what's going on. And as Alexandra said, if you have any questions, please put them in the chat box as we're going. I don't want anybody to forget a question that they may have. Also, even though this isn't open where, I can see all y'all's faces, if you have an experience or something that maybe was a little bit different than what I've experienced, please put it in there. I'd like to visit about it. I think that we all learn the most from each other's experiences. So basically, I'm going to get started off with just a real general discussion of what is mediation. And, for those of you that have mediated, I know that this may seem a bit just redundant, but it's basically an assisted negotiation with a neutral third party. There's a lot of stuff about when to do it and stuff like that. The biggest takeaway I have is I prefer to do mediation basically after discovery is done and after depositions are done, but that's not going to be the same in every case. I've had cases where I had a not great client, and so I wanted to get to mediation prior to their deposition being taken, because I believe that would harm the value of my case, having my client speak. I do think that having written discovery is great. I think it helps the mediator have a better picture as to what to expect, the facts of the case, because whenever you have a mediation, whether it's a half-day mediation or a full-day mediation, you're not going to spend that time doing fact-finding. So having discovery and helping the mediator already know what's going on, you can get down to negotiating instead of just going through, well, actually, these are the facts. No, we disagree with that. That's why I like having everything through discovery already laid out. So typically, who attends, again, very general stuff. If you represent, let's say, an insured, the insured typically won't come, at least in my experience. They usually send an insurance adjuster. That's the person with the authority to settle the case. And that's really who needs to be there, is the person that has authority to settle the case that day. Without that person, there's not a whole lot that you're going to be able to get done. You know, whenever it's a plaintiff, you know, you want the plaintiff to be there. But whenever you're on the defense side, that can change a lot, especially if you have issues of like, you know, a person getting sued, but then there's negligent entrustment. There's another person involved. You've got to have the person that can make decisions to get the case settled there. You know, before COVID, typically mediations are held at the mediator's office. And basically you come in and the mediator gives his opening statement. It's always a general thing. As attorneys, you'll hear it, I mean, countless times. Just an introduction, kind of the rules of mediation, what to expect. And the opening is just kind of to make the parties feel at ease and understand what's going on, because typically your client will not have been in a mediation and the whole process will seem a bit foreign to them. So after all that, usually, and this again depends on what the parties want, but there's usually party presentations where the plaintiff will say, look, we brought this case for these reasons. Defense will say, yes, you know, we deny liability, or, you know, these are mitigating factors. And basically they put out there what they believe is going on with the parties. And then at that point, the mediator holds what is called a joint session. That's where he asks questions that are open while both parties are in the room. This is to kind of explore general facts, kind of see what's going on with the case, see if there's anything that the parties sitting there in the same room agree upon. That way, where those are things that we don't even have to address whenever we break out after that. Once the joint session is completed, the mediator will put each person in their own room. Again, this is back in COVID time or pre-COVID times. And then we'll start going back and forth to each room to discuss more, I guess the best way to put it is they're going to discuss issues more on point, you know, not to, I guess I'm trying to think of the best way to say it. They're going to be looking at hearing from the other side without concern of the side that they're going to address later. You know, they'll ask questions completely on point, you know, stuff that they didn't want to ask while the other party was there, as it may have caused friction. And as a mediator, the last thing you want to do is cause friction, especially in that joint session. It causes problems in the negotiating process right off bat. You want to try and keep everybody in a happy mood to the best of your ability. At that point.
Wait, I have a question here.
Yeah.
So one thing I know that I've experienced is once the joint session is over and the mediator comes into your room, sometimes it feels like the questions that they're asking are very like, maybe almost not biased, but very maybe disbelieving towards your side, or very, you know, either pro or against your side already, even though all you've done is give like a very general statement at the beginning. How do you handle a situation where you feel like maybe that mediator isn't so much trying? I know there's different styles. I know some like to like seem more tough, but like, how do you handle a situation where you really feel like you're starting off underfoot?
Yeah, that's a really good question. And that was something I'm absolutely going to address later, but we'll jump to it now. Mediators, just like attorneys, they have different styles. There's some mediators that come in there and they want to challenge your case from the get-go. I consider that to be kind of like taking that person's client and bringing them into reality. And I have some examples where we'll talk about just basically being reality checked and bringing our clients' expectations back to reality, where mediation can benefit that. You know, whenever you look and you go, you know, you get your certification stuff, the professors I had said, absolutely don't show any sort of bias. You need to remain completely neutral. But I find that to be a challenge, because at times to get people to understand there may be flaws in their case that they're just not considering, you've got to challenge them and say, what are you going to do about this? You know, you're in this court. This judge doesn't allow this type of evidence in. How are you going to address these things? You know, it's easy to say it in, you know, joint session or here with me privately, but how are you going to address that whenever you actually go to trial if this case doesn't settle today?
And then I got some questions in the chat here. And I'm going to just read both of them. Are there situations where you recommend against having a joint introductory session? And is it common or uncommon for a plaintiff to want an introductory session, but the defendant doesn't? And what do you do in those situations?
Yeah, I think that those are good questions. So the time, you know, I've had joint sessions in the personal injury realm as an attorney, where it was just the plaintiff didn't want to see the defendant. You know, that person T-boned me, hurt me so bad, I don't want to see him, all that. Okay, those are very clear. Another time that joint session may not be a great idea is in a divorce case that's really contentious. You know, maybe, you know, the husband and wife, just from the bad blood, they don't want to see each other. Again, you want to get out there and try to have everybody on the best foot, so that they want to negotiate and get things done. Whenever people get in there and they get frustrated, they get mad at seeing each other, that's going to make negotiation more difficult for the mediator. So it is kind of, you know, up to the mediator what he thinks is best, he or she thinks is best. And then about it being common, whether or not the plaintiff wants one, whereas the defendant does not. I know in my experience that there's been plenty of cases, whereas defense attorney, I really had nothing to add to a joint session. And the mediator would come into the room and say, Mr. Martin, do you or your client want a joint session? I'd say, you know, not really, we're indifferent, we don't have anything to say. And he'd come back and say, well, they want a joint session. So whenever that occurs, I go in there, I sit down, I listen to what they have to say. Usually it's basically what's written in their petition, maybe bolstered by some facts found in discovery. And then, you know, all I say in response is, hey guys, we're here in good faith to try and get this case resolved today. And that's what we hope for. Now, there are other cases where, you know, you get your chance to talk to the plaintiff and really kind of, you know, explain why you think that their case is weak. And again, those are some examples I was going to explore later. So we got down, you do the private caucuses, that's where we left off. At that point, the mediator, you know, will continue looking at, you know, issues and evidence, discovery, things like that, whatever he or she has available. And for personal injury especially, it just kind of gets down to throwing numbers back and forth. And the person that goes first would be whoever has not, you know, if the plaintiff has a demand that's out there that defense has not responded to, well, then the defense is going to have to make an offer before they go back to plaintiff. And with the personal injury cases, especially, it's a lot of back and forth. Whenever you do family law, and, you know, as I stated earlier, I'm not highly experienced in family law. I've only done one family law mediation. With those, though, there's a lot more at stake than just a dollar amount. Of course, you know, family law, you're going to have a savings account, things like that, but you're going to be dealing with child custody. You're going to be dealing with property, separate property, you know, community property, all sorts of stuff. And so it's not going to be as straightforward. It's not going to be, hey, we see your medical bills are $30,000, you know, but we'll give you 12,000. And they go, okay, well, we want 28, no, 13. It's not that simple. That becomes more of a mediation where, okay, well, if she gets this, then I'm going to want these things. And those are far more, I think, intricate mediations. And that's why the mediators that really specialize in those are really good at what they do. It's just a whole different process. So that's kind of the layout, you know, and you work towards the day and you either settle or you don't, and it's an impasse. So before I get into settlement and impasse, there's some other things I want to address, but I want to go back now and say, well, what is it like now during COVID? You know, people aren't meeting in the same room. You know, they're not going and sitting with their lawyer, and they're not sitting in groups. So that's why so many are doing it over Zoom. And I've mediated as an attorney over Zoom. I've done mediation over Zoom as well. And what I'm going to tell you is it's really, really similar to everything that we just talked about because of how Zoom is set up. So instead of it being a webinar like it is here, you know, I would hope or expect that most of you have been on Zoom conferences where you can see everyone's face. And so the mediator fires up the Zoom and everyone's there. They hold the joint session. And then the mediator, once they're done with that, to conduct the private caucuses, they put them in breakout rooms. So now you and your client or clients are going to be in your own room with y'all's images here, all by yourselves. You know, the other party with their clients, their attorneys are in another room by themselves as well. And that's it. And the mediator is able to jump back and forth. Then you conduct the mediation the same way. I think a good thing to have on hand is a phone number in case someone's, you know, internet goes out, a number to call in where they can be on the line with their attorney, because as a mediator, you want to be able to address everyone in the room. There have been issues where somebody somehow comes into the wrong room in the breakout room. As a mediator, you just need to be very mindful of who's in that room. And as an attorney, you need to be mindful. Pay attention to your screen. If you see plaintiff come in by accident, stop talking, you know, make sure that the mediator gets them out of there. And a lot of people are still learning how to work with Zoom and how to get through all this. So there's some that are better at it. It certainly comes with practice. So just pay attention. There's some issues over Zoom that as mediators we've had to consider, and I don't know how much it will impact your practice as an attorney, but whenever I'm mediating and I walk into a room and there's the client and the attorney, that's who I'm speaking to. Now, I understand whenever I leave, they could call someone, call the partner, maybe the client calls their business partner, things like that, but that's who I'm dealing with. You don't know who's sitting next to that person on Zoom. You don't know who's behind the screen, anything like that. So there are some unknowns out there. I think a good practice is to, you know, request the participants to, you know, be as by themselves as they can. I understand there's pets, there's children, things like that. But try to get their full attention, because how am I going to be able to negotiate with you and make my points and really get you to start seeing things to make you work towards the middle, towards settlement, if you're not paying attention, if there's somebody over here whispering in your ear, things like that, that becomes a problem. And there's really no way of escaping that with Zoom. So I think that that's a big flaw with Zoom. But I think ultimately Zoom is here to stay. Another issue I'd want to point out is using the chat box during a Zoom mediation. You can select in chat where your questions or comments go. I know I've used in mediation as an attorney, I've put out information straight to the mediator about basically what an email said. I copied and pasted the email and put it into chat. And it was something that I wanted the other side to see, that this is something that was produced. And so, you know, it went up before I double checked that. You know, had I only wanted the mediator to see that, it would have been too late and it would have gone over to the other side. So make sure that you select whenever you go to chat, there's a section that says to, make sure it's not all panelists or all, make sure you're sending it to whoever you want so that you don't, violate any type of attorney-client privilege. You don't lose some sort of work product that you just wanted the mediator to see, things like that. So just be very conscientious of those things. I guess, that's kind of, I can't think of any other big differences. I know Daniel, who's on here, he's done a Zoom mediation, and I spoke to him before this. He said he thought it went really well. I think that it is great. I think from other mediators I've spoke to in the family law, for family law mediations, like I said, it can be very contentious at times. Well, you have two people that now they're not even in the same building. And I've heard that in family law, it's been a quite beneficial thing to conduct family law mediations over Zoom. So I think that there are definitely pros there. I personally, prefer to be in person. I think talking to a computer screen is difficult. I think being a mediator and not being able to sit in the same room, see people's body language, and really like converse with them and get to know them, I think that makes a mediator's job more difficult. So I think that you lose that element of, personality and really getting to know someone in that time whenever you conduct it over Zoom. But overall, I think each case will dictate what's best. So I wanted to go through a couple of more things. Again, general stuff like the hallmarks of mediation. We covered this earlier whenever Alexandra had a question. The mediator is supposed to remain neutral. There's just some instances where sometimes you can't, sometimes you've got to call out the other side and say, how are you going to get through this? How are you going to present this argument in court? And really try and get them to budge by, basically considering whether or not what they think is going to be the thing that they drive home at trial. Well, what if you don't get it in? That's something that's always, I think, been helpful to me. Let's say I have a difficult adjuster that I'm mediating with, and they say, hey, at trial, we're going to do this, this, and this. And I go, I think that's really difficult to get some of those things in. And if we don't get them in, we are really not in a strong position to argue this case. And so whenever you have that mediator, neutral third party, typically they're experienced, they've done these things, they've tried cases. Whenever you have that person come in and go, that you don't have a shot at getting this stuff in. And, once the mediator leaves the room, now your client, the adjuster, in my experience, is more open to discuss settling the case, because now it's, you don't want to say, I told you so, but they get to hear it from someone else. And it kind of takes them off, where they were at, way up here, their expectations, and bring them back down to reality. And I think that helps a whole lot.
I have a question there. Sorry, that's sort of like the inverse of that. So I've had a case before where we got a court-appointed mediator that I guess nobody really chose. He was just given to us. And it was a case that both sides really did want to settle. And I think we both parties went into it really optimistic that it would settle, but the mediator just was having a hard time with the numbers. I think he kept mixing up the math, and we kept sort of getting lost in the weeds of that. And we were having a hard time trying to figure out how to make this mediation like productive for us, because I think we all wanted to settle while we were there. What do you do in a situation where maybe the mediator's not hostile, but is just, might not be someone you would have chosen, and it is for whatever reason really slowing down the process? I mean, what's the best way to handle that?
That's a tough one. I think if I were in your shoes and in that situation, I would, as an attorney, have to just take a much harder approach with that mediator. After discussing, in the private caucus, whatever we discussed, and whenever it came down to what information I wanted to go back to the other room with, you know, my offer, anything like that, I would really hammer in, these are the 3 things I want you to make sure that you tell the other side. Now, is he going to? I don't know. You know, there's some, you know, just ineffective mediators out there, and, you know, you can only do what you can do. But I think at that point, you've just got to try to drive home your points and hope that he conveys them correctly. And then, you know, typically I would expect something like that to end in an impasse. And then hopefully if both parties wanted to settle, maybe you got lucky and kind of saw where the other party would settle. Maybe you showed a little bit of your hand, kind of showing where your authority was. And that's whenever you get on the phone, you know, after mediation and say, hey, I know that we couldn't work it out, but here's what we've got. You know, would you be willing to settle? And maybe just do some informal negotiation, try and wrap it up after that.
And well, it's actually what we did. And that's one of my questions is, especially now that everything's gone electronic, how do you gauge whether your case is best suited for formal mediation, where I know it can cost money and it can take some time, versus the sort of informal, especially since it's not like you're meeting in person anymore? Is there a difference, you know, a time when you recommend one thing over another?
I think that, I mean, I think each case is different, honestly. There's some attorneys out there that they're not going to negotiate with you in any sort of good faith from the get-go. And I think that those are cases that from the onset, you're going to know, hey, this case is going to need to go to mediation, you know, just to see if we can get it settled. There are other attorneys that I've worked with that we just, I don't know, we have a really good relationship, and I'd see them pop up on the other side and I'd call them and go, look, you know, send me over what you've got. Let's see if we can get this settled before, you know, having to do discovery, retain experts, depositions, like, let's see what we can do. And in those cases, you know, yeah, it was effective sometimes it was not. Again, that's where maybe you go to a mediation because one side just has somebody that won't budge, that they expect, you know, if they're a plaintiff, they expect a windfall, you know, oh, I got in a wreck and I've seen these commercials and I'm going to make so much money, but really it was just a fender bender, you know, and it was, you know, maybe just some really, really minor injuries, maybe nothing at all. They don't have any medical records other than like an ER visit. Well, you're not going to get, you know, 6 figures on that, you know? And so it's nice to then get a mediator to come in and kind of just shed some light on the reality of this situation. I just think that each case is different personally, and you just you got to gauge it, and it comes with experience, you know, who you've had success with, both on the other side as an attorney, both, you know, as well as a mediator that is, you know, really helped get cases settled for you. And those just kind of come with just trial and error, and you'll figure it out. A biggie that I want to talk about, and maybe I should talk about it earlier, is mediations are confidential. Everything there stays with the mediator. Everything you tell the mediator, obviously not in joint session because the other party's there, but anytime you're in private caucus, all that is confidential. And a mediator should not say anything from the private caucus to the other party without you telling the mediator that you would like that information shared. I know before I jump to the next room, I kind of go over what I discussed in that room with the parties and say, now, is there anything there that y'all don't want me to tell the other side? Sometimes that happens. Sometimes they, you know, say, yeah, the information from this email, we don't really want them to know about it yet. You know, so just hold that off. Make sure that you tell your mediator things that you want to remain confidential. A good mediator, he should double check on everything before he leaves. But, you know, sometimes you just get busy and sometimes, you know, you forget to double check. So just help the mediator out by doing that as well. And, anything you tell the mediator can't ever be subpoenaed. Nothing's going to come out with the figures. If you tell them your top authority and y'all never get near that, everything is confidential. So that's another really big hallmark to, the mediation process, is that everything just kind of stays there. And that's to promote, trying to get cases settled, that parties will be more open, more honest with the mediator in hopes of settling. Some other things that are just very general, but, why mediate? Why try and get the case settled? Well, it saves time. It saves expense. The parties know what they're getting. They're in control of the outcome, that they're in control of what they get. So, that's one thing that mediation can help with, is kind of empowering the participants that, hey, today you get to kind of figure out how this thing resolves. Whereas whenever you go to a trial, a jury trial, you have no idea which way, the hammer is going to fall. And I think that those are good things to try to tell your clients up front, so that they come in with an open mind, knowing that they're not going to leave there typically getting every single thing that they want. But they can leave that day knowing what they're going to get, and also without all the extra expense, stress. And then, by the time you get to trial, I know that courthouses have been backed up. It can be years. It's just beneficial to get in there and mediate if it's a case that is one that can be settled. One thing that Alexandra asked me earlier was about, different types of mediators coming in and really hammering you. That there's a bunch of different styles that I think that you'll come across, and that's just everybody has their own negotiation styles. I've had mediators that they didn't like the insurance company I was working with, and so they came in and they were just we were the enemy, it felt like. They came in and just from the get-go just started hammering on us. That doesn't promote settlement. It really just entrenched my adjuster to not budge. So I don't think that works. Now, I've seen not such an aggressive approach, but still coming in and hammering, and like we talked about earlier, kind of bringing them to reality. That's okay. But you'll probably come across mediators that may not like you as much or may not like your client. And that's just something that you have to deal with. I've had really, really passive mediators that they really come across as they don't care. Not to the point of they're being neutral, just the whole, I don't care, you've paid your fee, what number do you want me to take to the other room? And those are not helpful at all. Not ineffective, like Ali's example with, somebody that can't get the facts or the numbers right, just a person that's nothing but a messenger. Those are really ineffective. Now, I've also seen mediators that like to try and guilt the participants and go, oh my gosh, you're only going to offer that amount of money whenever, they've been to the doctor 50 times. Like, I can't even go over there with that. You've got to do better. And again, that's not effective because, again, it makes it feel like that that mediator is just there to basically promote the other side, that they've really picked a side, and that, it's not going both ways. So the best type of mediators, in my experience, are the ones that just get in there, that they try to be honest, they try to look at things. I've always really appreciated it whenever it's a mediator that has trial experience. Even better if they've tried a case in front of the judge in the court that I'm in, or maybe they just know the judge really well. And, to sit there and be able to have an honest discussion with them about that judge, about how we would like to present our evidence, and have them say, typically judge won't let that in. Typically, he's going to grant this motion to strike, things like that. It helps me have an honest evaluation on the case. It helps me speak to my client and say, these are things that without, it really alters the arguments we can make, and therefore alters the value I put on this case. And those are, I think, the best mediators in my experience. It helps get the case resolved, and it brings everybody to reality.
I have a question real quick.
Yeah.
So going back to what you said earlier, in tying into what you said now, and being able to have an effective mediation. I know that there are some courts that not just appoint mediators, but that tell you when you have to do it. Within the first X amount of days of the case being assigned to a court, you have to go to mediation. And a lot of times it's, cutting it close that you may or may not have written discovery, especially if the other side comes and asks for an extension, you won't have it. What do you do in that situation? Because, when it's happened to me, I find that I go and I pay and I don't get a whole lot done. And is there any way to sort of make those faster sort of court mandated mediation something useful, or what's the best way to approach that?
I think on that, and yeah, that there are a few courts here in Harris County that mandated. There's even fewer that mandated on a timeline like that. My suggestion would be, if you can't get discovery done in time and both parties are agreeable, I'd file an agreed motion to extend deadline. And, don't just set it for submission. Go ahead and set it for hearing, and, tell the judge, look, this is a case that we think mediation's going to work out and get this case settled, but we need an extra 60 days. We want to have depositions, and we want to, conduct written discoveries so that we can make a good faith attempt at settling it. Then it's into the judge's hands whether or not he grants that. But I think with both parties going in front of him, not setting it for submission and saying, this is why we think it can get settled, maybe that the claim is within policy limits, things like that. And, you can make an argument there. I think that a judge would be likely to grant that, especially if you're not asking for an incredible amount of days, like 6 months or something. 60 days, that's plenty of time to conduct discovery. That would be my recommendation to do it. And yeah, I mean, you can correct me if I'm wrong, but I think that there's only one judge that mandates it within an actual time period. But I know that there's quite a few that mandate mediation prior to trial. So I know that we're getting close on time. I just want to kind of cover some of the stuff at the end, just my experience, what helps. And so whenever you reach the end of mediation, it's going to hopefully end in settlement, but it could end in an impasse. Just some tips and tricks for me, if it gets towards settlement, the mediator's going to provide a mediated settlement agreement. It's going to be very general typically, but it should reflect the terms of the agreement. Double check it, because whenever you sign that's a settlement agreement. And the Texas Supreme Court has ruled that a written settlement agreement reached after mediation is enforceable in the same manner as any other contract. That was an opinion from 1996, Mantis versus Fifth Circuit. So whatever you sign that day, it's going to be enforceable as a contract. There's been terms that we agreed to in mediation. I've done mediations for basically homeowners insurance, and they'd want to replace a roof, and you have to have amounts that go to the mortgage and then to the client, and they would include those amounts incorrectly. Make sure all the terms that you agreed to are correct in there, because you don't want to execute something and then have the attorney on the other side say, look, we agreed to it and you signed it, and you go, I just messed up. That's malpractice. So make sure that you know what you're signing. Add whatever information when necessary. Whenever I do that, I kind of circle it and put my initials by it, and I ask the mediator to get the other side to initial it and get the mediator to initial it as well. That way, where there's never, some argument that, hey, you slipped that in and I didn't see it. You just don't want to have worked all day to get to a settlement only for it to blow up over a typo or over some term that wasn't included. And then now you have a whole different headache. For more complex cases, or let's say it's cases that I've had a very problematic client or opposing counsel has been extremely problematic, I will have drafted up my own settlement agreement. All the terms I want, obviously not the settlement amount and things like that, but I'll have that on my laptop ready to go. That way to where I can add in the terms and ask the mediator to print it and get them to review it and try to get them to sign it that day. The reason for that is you don't want them to leave and try to reconsider anything. And if I have my settlement agreement signed, the one that I've drafted, I'm happy with, it's going to be a lot more specific than the general mediated settlement agreement. I'm going to feel really good leaving. The case is wrapped up, and I don't have to worry about, in my more specific release and all that, opposing counsel coming back and starting to fight me on other things. So if it's one of those, get it all wrapped up, because whenever people leave, if there's any type of term that they can change or wiggle around, they're going to, because they're going to talk to somebody and that person's going to say, you agreed to that? Why? And that's the last thing you need is to be undermined. And even if you just do the mediated settlement agreement, leave with a copy of it. Just, don't say, yeah, just scan it in and email it to me. Make sure that you leave with a copy of it. That way where you scan it in and you know what you've got. Just take care of it. You worked so hard to get that far. No reason to just, get out of there without having everything that you need. Now, if there's no settlement, that's called an impasse. Typically at that point, the mediator will declare an impasse and ultimately write notice to the court that just says, hey, there's an impasse, but if there's anything I can do in the future, I'd be more than happy to help. And that's that. You can always go back and remediate with the mediator. I've actually never had to go back and remediate a case, nor do I think I know anyone. Now, I've heard of parties being ordered to mediate again, but I've never heard of anybody going back, but it is an option. The other option that I've found to be really beneficial is called a mediator's proposal. And for those of you that don't know what that is, after you've negotiated all day, let's say that you're $10,000 apart, and say one party's at 10 grand, the other party's at 20 grand. It's an impasse, nobody's moving anymore, everything's final. The parties can request a mediator's proposal, at which point the mediator will review everything and he will draft up a proposal for both the parties to review, and it will be for an amount in between those two numbers that the mediator believes the case should settle for. So it may not be right down the middle. My example, though, it would have been 15. It might be like 16.5. And basically, he issues that. It goes back to both clients. And, if you have an adjuster, it's got to go up the chain and everything like that. And the parties have a set time period to agree to it. Now, you won't know the other party agreed to it unless you agree to it. I guess, you would know if the other party rejected it, if you agreed to it and they rejected it. But it's not considered settled until the mediator, no later than the deadline, receives, written confirmation that we agree to your mediator's proposal. And at which point, whenever both parties agree to it, you get an email basically that says, congrats, this case settled for the mediator's proposal in the amount of, in my example, 16.5. I think that those are great. Some mediators do not want to do them. They don't want, they think it impacts their impartiality and their neutrality by actually placing a value on the case. And so there are mediators that are opposed to it. I think in simple cases, like in my example, you'll probably find a lot of mediators that will do it. I've found them in my practice as an attorney to be very beneficial. I think I put it over 50% of cases that came down to mediator proposal ended up getting settled through the mediator's proposal. So if it's something that's close, I'd recommend it 100%. Now, if it's a case where y'all are $150,000 apart, I mean, I just think that that's too much, but I guess it also depends on, you know, really all the other factors at play. You've got to really see if this is a case that you're close on. And if you are, I think it's something that you've got to go for. That's really kind of all that I have. I don't know if you have any questions or if Daniel has any questions, but that's basically mediation in a nutshell. And basically everything we talked about is pretty much the same, whether it's in person or through Zoom. Zoom just offers just a different, you know, mechanic to get it done.
And I just put it in the chat box, but in case anyone missed it, the course number is 174097504. So make sure y'all put that on your State Bar of Texas a CLE page so you get credit for it. And just to echo what Austin said, if there's any questions, go ahead and let us know.
Yeah, but let's give it a few minutes just in case there's any questions. Also, I believe on this course number, guys, I know that these videos go up onto YouTube. And once they go live on YouTube, I don't think that the course number is effective any longer. So try and go ahead and get on the State Bar page and throw that course number in there today, just so that you can make sure that you get credit.
And I have a question while we wait for more to come in. One thing that I've seen an increase of is people using media in their opening statements. So like I've seen counsel who have these elaborate, almost trailers of the case made set to moving music. And I've seen PowerPoints, and I've seen just a huge increase in the amount of technology that people utilize. I mean, what's your opinion on that?
I think each case dictates what you need to do. If I have a case, let's say, especially if it's wrongful death, maybe it's a multi-million-dollar case, yeah, I'm going to put in a little more effort than if it's a, you know, minimum policy limits of, you know, $30,000, less than that value of a case. Not that the effort dictates what's going to come out, but whenever you have something that big, there's typically a lot more pressing issues. There's things that you want that mediator to see. Whenever you have minimum policy limits, you probably don't have all those issues that you've really got to get out there and just show what's going on. You know, usually it's, hey, accident happened, they went to the doctor, these were the diagnoses, and here are their medical bills. You know, whenever you get into those bigger cases, there's so many other things. You know, you've human factors, you have, you know, their earning capacity that you've really got to show. So I've seen that on bigger cases, absolutely, where they're looking at close to $750,000, $1 million. I'll see counsel do that. I think ultimately, if you think your client will benefit from a PowerPoint, from a video, that it's going to push your message and get the mediator to kind of see what's going on, get the other side to see something maybe they haven't seen, and it's going to ultimately benefit you somehow, other than just kind of like bolstering your own client, I think that you should do it.
I think those are my questions, and I don't see any popping up. I see that Daniel's still on here. I'm going to assume he doesn't have any questions because he hasn't said anything. But Austin, thank you so much for your time and for talking with us today. If anyone has further questions on mediation, or you just want to continue the conversation, his email address is, I'll put it in the chat, is amartin@mgtexaslaw.com. I'm going to do it right now before I forget. Thank you guys so much for your time, and thank you, Austin. Yeah.
Let me jump in real quick. I just want to add in here, y'all. I volunteer at the Dispute Resolution Center, and that's something for if you have any cases that are like under $100,000, less than 3 parties, like smaller cases, you may be able to go and get mediation there for free. So look into that. There are options out there. I think it's a great group of people, and it helps new mediators like myself get experience. I'm over there doing personal injury mediations. So if you have more questions about that, let me know. But I just wanted to kind of give them a plug because they're a great nonprofit organization that's helping out here in Houston. And right now they're doing everything over Zoom as well. So you don't have to worry about it being in person. Just look up Dispute Resolution Center Houston, and that could be a good option for cases where, you know, maybe you don't have a lot of room for much expense, and they're not very high value cases. It'd be a good opportunity for you and your clients.